Good afternoon, everybody. First of all, thank you to our colleagues from CMU. It's always nice to do our presentations. And as Kit mentioned, we actually have some good news to talk about today, which is very welcome, considering what we've had to talk about over the previous 4 years. So we're happy to do that and happy to be here. And again, thank you to Kit and the team for putting this program together. So I'm Larry Lebowitz, and I'm here, as Kit mentioned, with my partner, John Brendel, and we are the senior immigration lawyers at Dentons, Cohen & Grigsby. We're honored to have had Carnegie Mellon and the University of Pittsburgh as clients of our firm for a long time. And I work very closely with Linda Gentili, who is the outstanding DSO. I'm sure she has a more different title than that at CMU. Who I asked to say a few words when we begin. But let's start by sort of setting the stage for our discussion today. Our discussion today relates to a common scenario with many of you on this call are facing or will be facing, which is you have graduated from, let's say, a master's degree program at Carnegie Mellon. You are a foreign student here in F1 status. You have developed in the course of your academic program a really, really exciting business opportunity, which could well result in job opportunities, not only for you, but potentially for US workers as well. And you are graduating and wondering, how is it that you are going to be able to further develop this wonderful business opportunity, this business that you have created, and be able to stay in the United States to do that. So the first step, which has always been available to you, I'm going to ask Linda to speak on, which is curricular practical training and optional practical training. Once Linda does so, we will then lead into other options that could potentially be available to you, but which traditionally have been very, very difficult for foreign students, oftentimes, unfortunately, resulting in these foreign students needing to leave the United States and leave this really nice business undeveloped in the US. And finally, John is going to talk about what hopefully will be a solution to this problem, which is the primary topic of today's discussion of international entrepreneur parole. So that is a solution to the problems that are facing many people in this situation. So that's the stage. You're graduating, you are looking to develop an idea, and the first thing you do, hopefully, is contact Linda or somebody in her office to talk about CPT and OPT. So Linda, please.
Thanks, Larry. And if you're a Pitt student, you're going to contact someone in OIS, but I'm going to make a guess that many of you are in F1 status. If you're in a different immigration status, there may be other restrictions, so I'm not going to go into that. But with respect to F1 status, the most common employment authorization is practical training. Sorry, I've got jabber dinging on me here. So practical training is the most common employment authorization that students in F1 status use. If you are working for someone else's startup, curricular practical training may be an option if an internship is required or an optional part of your curriculum. You cannot work for yourself. You can't be your own trainer with CPT. You may be able to be working on a company that you are involved with, but you can't be your own trainer. So CPT doesn't always work out for those of you who are entrepreneurs. Optional practical training, however, is definitely an option as long as you are doing your work that is directly related to your major field of study. So it's always important to remember that any kind of practical training, curricular or optional, or STEM OPT, has to be a job that's directly related to your major field of study. Beyond the 12-month period of OPT, there's the STEM OPT extension that many of you are eligible for. There is some potential of using that for an entrepreneur startup, but bear in mind that not only the person, but the company has to qualify for the STEM benefit. So it has to be an E-Verify, fully participating in the E-Verify program company. Carnegie Mellon is not a qualifying employer, so not every company who's in E-Verify qualifies. And you, like CPT, you cannot be your own trainer. So if you are creating a company with someone else, you may be able to use the STEM extension. But if you're the sole proprietor, you wouldn't be able to be your own employer on the STEM benefit. So each F1 benefit has slightly different rules, but definitely the 12-month OPT is your best option for your own company. So you want to look at those options and explore all your student options. And then Larry and John can give you more advice about what comes beyond F1 status. So I'll switch it back to you, Larry.
Great, Linda, thank you. So for sure, looking into the CPT and even more OPT options is the first step. But what happens when you get to the end or you're approaching the end of your OPT? What options do you have? So let's go to the first slide, please, Kit. There we go. Okay. So the idea, one of the underlying premises of the US immigration system is the ability of an individual to make an investment into a US company. The idea being is that that investment would result in potential job opportunities for US workers. And the idea, which is a very good idea, is that that investment will not only create a job for the investor, but other, as I said, US workers. So this visa idea, this premise says that in order to make that happen, we're going to allow the person who is the investor to be able to spend time and work developing this investment in the United States. But as this slide reflects, this option is unfortunately very limited. First of all, how much of an investment is required? Well, a substantial amount. There is no specific amount that's required, but that amount of money must be substantial in relation to the nature of the business. So for example, if it is a manufacturing concern, the amount of money invested has to be more than if it was, say, a startup software development company. But again, certainly a substantial amount of money is required. Next, you have to show that the applicant is capable of developing and directing the enterprise, meaning passive investments, simply investing money and not engaging in the business is not permissible. And also, as mentioned, it isn't sufficient that this investment, this business, results in enough money to support the person, the investor, but must also generate enough revenue that it would also pay US workers. Okay, next slide, please. The visas are good if you're eligible for 5 years, anywhere from 6 months to 5 years. Importantly, as some of you know, one way to obtain a green card is a process known as labor certification, where the employer is required to test the US labor market to determine if there are any qualified and interested US workers for that particular position. Under the law, an E2 investor cannot be the beneficiary of a labor certification application. So as a result, if you are an E2 investor and that is your only basis of ultimately being a permanent resident, there is no option there for you to become a permanent resident. But for our purposes, and knowing, I think, the majority of people on this call and who are in this situation, the E2 visa requires a treaty between the United States and that particular country, the person's country of citizenship. And unfortunately, there are no E2 visa treaties between the United States and China or India. So if a person is either a Chinese or Indian national, the E2 visa is simply not available. Okay, so what are some other options facing our student? You may have heard of this EB5 Employment Creation Immigrant Visa or Green Card. This is a category that was created consistent with the E2, where if somebody is capable of making a substantial investment, not only are they potentially eligible for an E2 visa, but also actually a green card. And not surprisingly, the stakes are higher, but this time the actual amount of money is stipulated. And as the slide reflects, what we're talking about is an investor committing $1.8 million into a new commercial enterprise, which amount is cut in half to $900,000 if that business is in a targeted employment area, meaning either a rural area or a high unemployment rate that is 150% of the national average. Makes sense that the amount of the investment would be lower in an area where there is already high unemployment, again, so as to create additional employment opportunities for US workers. Now, the EB5 category has been riddled with all kinds of challenges and all kinds of problems. So the actual status of it is always a bit murky, but as of now, it is still available. Again, 10 new jobs must be created. So this is a situation where, unlike the E2, where there's no specific number of jobs that need to be created, the EB5 green card category says that this investment must create at least 10 full-time jobs for US workers. And again, the EB5 investor has to be directly involved in the management day-to-day operations of the business. Next slide, please. So what are the problems with the EB5 category? Why is it not an easy option for our CMU graduate? Well, first of all, that's a lot of money. $1.8 million or even $900,000 is obviously a lot of money. Number two, the requirements, the documentation requirements are very, very heavy. And as a result of that, the adjudication process for an EB5 green card is very lengthy. So while in spirit, the EB5 investor visa green card category is very attractive, for our students at CMU, it is likely going to be impossible or at least difficult to pursue. Okay, so let's go on. What's another option? Well, how about this other green card category that maybe you've heard about, which is an EB1A category for people with extraordinary ability. These are the best of the best. And unlike most green card categories, people can self-petition, file this immigrant visa petition on his or her own, proving that he or she has, quote, extraordinary ability in the field. Now, again, this is available potentially, but thinking about our common scenario where this is just a recent graduate of a master's or maybe PhD program who is really just starting his or her career, you can imagine that is a very, very difficult category and one which we've looked at for some CMU graduates, but very rarely would be able to pursue it. Okay, next slide, please. Okay, well, how about this EB2 category? EB2, professionals holding advanced degrees, that is people who have at least a master's degree. Okay, we're going to meet that requirement, but also people whose work is in our country's, quote, national interest. The general rule is with an EB2 application, you need to have an employer file an application on your behalf. Well, that can be very problematic because, as I said, it requires a labor certification application. And if you own the company yourself, filing a labor certification for yourself is very problematic. But there are certain ways to avoid having to have a company file on your behalf. One of them is arguing that, again, you have an EB2 category, you're a master's degree or higher, and your work is in our country's national interest. So this is a nice option if your work is indeed in the country's national interest. And as point C reflects, the typical cases that we see are people who are working in areas of national defense, healthcare, etc. And again, thinking about this for a typical CMU graduate who is perhaps just starting his or her business, being able to demonstrate that that business is already one that is serving our national interest is a challenging task. So something to consider, but also quite difficult. Okay, next slide, please. Well, we've all heard, I think, about this other visa category called the H1B visa. Okay, the H1B visa is one where an employer files a visa petition specifically for an H1B visa on behalf of an employee of that company. Now, if the CMU graduate incorporates a business, that company is able to file an H1B petition on behalf of the employee / owner, even though, again, the owner is the owner of the company. So in this case, the owner of the company would also be the beneficiary. That is possible, but there are a couple of issues here that we need to consider. One, we have to make sure that there's a clear delineation between the company itself and the employee. So we would have to make sure, for example, that there is somebody supervising the employee, for example, a board of directors, so that there is a division, if you will, between the company and the employee. But even if you can show that there is that distinction between the two entities, the big issue with the H1B visa is the H1B quota. I've spoken many times in previous presentations about this issue, which is simply there's a limited number of H1B visas every year, specifically 65,000 plus an additional 20,000 for people with US master's degrees or higher. And because of that number and because of the demand for H1B visas, there is always a lottery, an actual lottery held every year where roughly the government receives 200,000 H1B petitions for 85,000 slots. So because of this lottery, and even if you can establish a company and file an H1B petition on behalf of yourself, and even if you can demonstrate that distinction, it is still very difficult to get through that H1B lottery. And second, there is an important requirement in the H1B regulations that all companies are required to pay all H1B workers at or above the prevailing wage rate for the position in that particular area. So for example, if there is a CEO of a company or a senior technical director of a company, which probably the CMU graduate would be, the prevailing wage rate for that position in Pittsburgh, for example, would be quite high. And with this company being simply just getting started, a startup company, it would be difficult, if not impossible, for the company to satisfy the prevailing wage requirement. Okay, next slide, please. So, okay, we can go to the next one. Go ahead, Kit. All right, so that's why these options, as you can see, are potential options. A couple years back, this new thing, International Entrepreneur Parole, came onto the scene at the end of the Obama administration. We were all excited. Kit brought us back in to talk about it. We were getting ready to roll it out. And the next thing you know, it went away. So that good option was gone for the past several years. Well, it's back. And so a new option available to a CMU graduate is now worthy of discussion. And I'm going to turn it over to John to talk to you about it. John.
Thank you, Larry. The International Entrepreneur Parole opportunity was created to plug some of the holes that Larry just mentioned. There's no annual quota, and all nationalities, unlike the E2 visa category, for example, that requires a treaty, all nationalities are eligible. It was set up in particular to create a vehicle for a young entrepreneur who doesn't yet or hasn't been able to acquire the personal capital, but because his or her business plan is promising, can attract that capital. The I'll just go quickly through the tortured history for the last 4 years. It was 2017 when the Obama USCIS first announced the program. Next year, new president. The Trump USCIS withdrew entrepreneur parole. Next slide, please. But as happened in so many of the anti-immigration initiatives of the Trump administration, the Trump USCIS failed to comply with the Administrative Procedures Act. So a federal court ruled that roll back the revocation of the program by the Trump USCIS was unlawful. So USCIS was required to accept and process applications. However, very few applications were filed because then the Trump USCIS began the required steps that it had to take under the Administrative Procedures Act and sat on the very few entrepreneur applications that were being submitted. So with the future demise of the program, not surprisingly, there were very few applications. However, the 4 years ran out on the Trump USCIS. It didn't complete all the steps that the Administrative Procedures Act mandates. And so with a new president and a new USCIS, we turned the page to 2021. The last month, the Biden USCIS withdrew the pending elimination of the program. Next slide, please. And announced that it would look favorably on international entrepreneur applications, which is as important since there's so much administrative discretion in these applications as the letter of the regulations itself. So now we have this new opportunity. There's no cloud over it. Parole is neither an immigrant visa, which is to say permanent visa or green card, nor is it a non-immigrant visa. We know them all by letters of the alphabet. So parole is instead a permission to enter or remain in the US. And the International Entrepreneur Program has the capability of 2 30-month periods of operation in the US. So what do you need to do to get the first 30 months? Well, the applicant must own at least 10% of an entity which has been created in the past 5 years. Should not be a barrier for a recently graduated CMU or Pitt student. The applicant must have an active and central role in the operation. Similar to the E2 visa, this is not an opportunity for a passive parole. And I'm sure the entrepreneurs listening to this don't want to be passive. Next slide, please. It must be established that the entity has substantial potential for rapid growth and job creation. That's amorphous, but the regulations then specify exactly how one does that. There are 3 options. You attract $250,000 minimum from a venture capital firm or an angel investor or startup accelerators. These must be US citizens or permanent residents, or if it's an corporation or partnership that has to be owned at least 50% plus by US citizens or permanent residents. And these investors must regularly make investments in startup entities. So you can't short circuit the procedure by funding a venture capital firm, for example, that then turns around and funds you, the international entrepreneur, parolee. Or you could win a federal or state or a local grant of at least $100,000. Pennsylvania has some of these longstanding programs. Or to typify the flexibility of the regulations, you can have a combination of A and B. That will require a lot more explaining, but that's a welcome flexibility to the hard and fast dollar amounts in A or B. Next slide, please. The wonderful advantage of this new kind of parole is spouses and children receive that 30 months as well. And in addition, the spouse can receive an employment authorization document, otherwise called an EAD card. So that's a huge benefit. The H4 spouse, for example, can only get an EAD card if the H1 is the beneficiary in an approved I-140, which can take a couple of years. So this is a very family friendly option. The material changes can cause USCIS to revoke the international entrepreneur parole. I'll just mention the highlights of the material changes. One is if the parolee has a criminal justice problem. If the new entity is sold, if the new entity goes bankrupt, if the entrepreneur ceases his or her role. These are all bases for the USCIS to revoke the parole. So for the second 30 months, the period, the requirements are a little stiffer. There's still the requirement to demonstrate rapid growth in job creation. The applicant must continue to own at least 5%, down from the initial 10% of the entity. And of course, must continue to play a guiding active role. Next slide, please. And we have the investment criteria again. This time, the additional investment or grants are an additional $500,000. And the regulation provides for these dollar amounts to be increased every 3 years. Or the company could have achieved revenue of $500,000 with average annual revenue growth of 20%, or the creation of 5 full-time jobs for US workers, not family members of the parolee. And again, the partial satisfaction of the 3 categories above. This is the hallmark of the regulation. Some flexibility involved. Next slide. So what's the processing time? Well, entrepreneurs or parole applications are not eligible for premium processing. Premium processing, you might have heard about, you pay an extra $2,500 filing fee, and in exchange, you get an approval or a denial or request for additional evidence within 15 business days. Not available right now for entrepreneur parole. The volume of cases is just not high enough to predict what the processing time is going to be. Coming out of, we hope, the pandemic, where USCIS processing times across the board increased, we hope, since the Biden administration, the Biden USCIS has announced that it's going to look favorably on these applications, that that means that there will be adjudication resources available and allocated to process these applications. Because if you have to wait 6, 12, 18 months to know if you're going to get the parole, it's probably not going to be very useful. The applicant can be inside or outside the United States. Very useful for any reason the student needs to return to his or her home country. That's okay. They can apply from outside the US. The investment cannot come from a family member or an entity controlled by the family member. Next slide, please. So I think we're, I'm going to turn this back over to Kit and Larry. I think we're at the question stage.
Yeah, thanks, John. It was great. You know, I think that hopefully the takeaway from this for everybody is that this is a really nice win-win-win scenario. That is, it's a win for the student looking to find a way to allow that business, that idea that he or she developed at CMU, to actually materialize and be a way for him or her to stay in the United States and help it materialize. It's a win for US workers who will have job opportunities become available to them by virtue of this new business that has been created. And finally, it is a win for CMU and for other universities who are working really hard to develop these kind of opportunities for their students who are able to develop these businesses that are created at CMU, and actually, again, to not only their own benefit, but also the benefit of US workers and the local economy. So it's really an exciting thing, and we're thrilled to be able to share some good news with everybody. So let me go to a couple of questions here we got, and there's more opportunity, by the way, if people want to ask. We don't have that many questions yet. Okay, I'll start here. With the H1B visa, must it be a board of directors, usually investors, or a board of advisors? So again, remember that the context is that the CMU student graduates, completes his or her OPT, and starts a company, and has that company file an H1B visa petition on his or her behalf. What I explained was that there needs to be a delineation between the company and the employee. And one way of proving that delineation would be to have a board, either directors or, in this case, advisors, who'd be responsible for supervising this person. So it would not only be the employee, former student, but it would actually be a board that was involved in the operations of the company. So the question asks whether it needs to be a board of directors, usually investors, or board of advisors. My preference, and I'll ask John to chime in, would be the more formal, the better. So a board of directors would probably be better, and there would be a clear statement as to the responsibility of the board to oversee the work of the employee. And again, that would be one example of a distinction between the employee and the employer. John?
I would just jump in and say concisely, board of advisors can't fire anybody. So I've done a number of these H1B owned entities, and I've always instructed my client, I want to see a board of directors, which under every state's law would have the authority to fire anybody within, any employee within the company. So I would say no to the option of a board of advisors only.
Okay. Next question. Can you use, and this is for you, John, can you use the IEP program to re-enter the US, or do you need a separate visa to do so?
Yeah, the parole comes with travel permission because you can get it when you are outside the US. And I should mention that at any time during this potential 6 years, 2 times 3 years, an individual could qualify for any of the other visa categories that Larry mentioned, or other visa categories, for example, being an immediate relative of a US citizen. So international entrepreneur parole is not the end game. It gives the young entrepreneur 6 years to get to a more final permanent immigration situation.
So let me add something here that was not asked, but it's related to this question, and people might be thinking, at what point should I apply for this IEP? So if you are in the middle of your OPT program, and as Linda explained, you can get the initial 1 year plus a 2-year STEM extension, you need to be mindful of how long it's taking the Immigration Service to adjudicate IEP applications. You know, thinking out loud, John, because we haven't seen it, somebody is in OPT status, an F1 status, they file for IEP. We don't know, I don't think, whether that would be granted on some type of a change of status basis, because it's really, as you explained, not a status. It's probably more likely, I don't know, that the person might have to leave the country and be readmitted in that status. Have you seen anything about that, John?
Larry, I haven't, but my gut feeling would be this is a long application form with lots of supporting documents. So I cannot envision even the best intention Biden USCIS processing these applications in a couple of weeks or even a couple of months. So my inclination would be to file as soon as I had a bona fide case, even if I had plenty of time left on OPT or STEM OPT.
And I don't think the application forms for IEP have even been issued by the government. Am I right, John? Or are they available from the previous time?
Oh, they're on the USCIS website. There's a mistake on the form, or at least the last time I looked, where it said you have to create 10 jobs to get that second 3-year period. It's 5 jobs. That mistake probably is the result of the EB2 requirement of 10 jobs.
Right.
But I'm sure USCIS, if it hasn't already corrected that mistake on the form, will correct it soon.
Okay. So practically speaking, everybody, the takeaway from this discussion is that if looking at those requirements, you think you may be able to satisfy them, it probably makes sense to start thinking about putting an application together sooner than later and taking advantage of this opportunity. Because as John said, we really don't know how long it will take the government to adjudicate these applications. Okay, next question. Can one take advantage of the IEP even during OPT period or H1B? John?
Yes. The timing is everything. Of course, if you succeed in getting H1B, remember there's the potential of 6 H1B years, and you see a path to permanent residence, which is difficult because of the labor certification requirement. But if you are EB2 national interest waiver or EB1 potentially eligible, that would be a judgment call. I would be looking at international entrepreneur parole in lieu of H1B visa status, not after H1B visa status.
Yeah, I agree with that, everybody. I think that this is sort of a fallback position for many people. And we also just have to be careful. This is a brand new opportunity for us that we want to seize, but we have to be careful. So before you go charging off and filing an application, you really want to think through some of these issues we're talking about, including how it would impact future status. And remember, parole is not an immigration status. It's not a non-immigrant visa. It's not a green card. It's a status that allows you to live and work in the United States, but not a status per se. And a concern that's in the back of my mind is if there is a change in administration, and if immigration policy returns to what it was before, there is, of course, the possibility that this program would be eliminated. And so we got to be thinking about those things as well. Okay, let me see if we get any more questions here. Okay, would winning a contest prize, such as the UP prize, maybe somebody can tell me what that is, the winner gets $150,000, qualify? And when you say qualify, I think you may mean for the EB1A category. Is that what you mean? Or do you mean, I'm not sure, John, would that fit into one of the requirements because it's not, an investment per se? What is the UP prize, Kit?
It's a local contest that has been launched by the Forbes Fund and Bank of New York Mellon. It was held for about 4 or 5 years, funded by Bank of New York Mellon. Last year, they discontinued it on a temporary basis. First prize is $150K, second prize is $100K, third prize is $50K. So it's not per se an angel investment or a VC, but it is showing that somebody thinks your startup idea is a really good one. And but there was a monetary requirement in the first 30 month period.
I forget whether it came in as a grant or as an investment. Was it convertible debt? Do you know?
It was absolutely 100%.
It's a grant. So it's a grant, basically.
Well, I would just jump in there, reminding people of that third, the venture capital angel accelerator, or federal, state or local grant, or a combination of A and B plus additional evidence. So I would say that this an UP winner would need something in addition to just that money, but he or she, I think, would be well on their way to satisfying the requirement for the first 30 years if they could get some additional capital, less than 250,000, or some additional federal, state, or local grant, not needing the full 100K.
Okay.
That's 30 months, of course, not 30 years, everybody. So I'm sure you got that. Okay.
So it qualifies.
Right.
Counted in the, okay.
All right, next question. Have there been any successful applications of IEP so far? If one has an O1 option, would the O1 be a safer bet at this early point in time? John, do we know if any IEP applications have been approved?
I'm not aware of any.
Yeah.
If there are, they're just a handful, and they would have been very recent.
Yeah, and so the question comes in, is the O1 a better bet? Well, remember, for the O1 visa, you cannot self-petition. But if you have a company, an employer that is willing to sponsor you for an O1 visa, and by the way, the O1 visa is for people with extraordinary ability in their particular field. If you have a strong case, that might be a good option, but that's really not our scenario. Our scenario is you want to work on your own. You're not going to be working for another company. You're going to be working on your own, developing your business. So I think that's the threshold determination that would have to be made there. Okay, next question. Would it be better to use OPT first, assuming you're eligible, and then apply for IEP to extend the time and get momentum for your business? Really good question. What do you think, John?
Well, I'd say if you've got that momentum already, then apply for entrepreneurial parole right then. But if you haven't attracted the capital or enough capital, then sure, continue on your optional practical training until you do.
And remember, you can apply for and obtain your OPT and simultaneously pursue the IEP. And if it's going to take as long as we think it might, then you might end up doing both of those things and taking advantage of both opportunities. Okay. All right. Another question. I will graduate in December of this year, December 2021. If I didn't get 250,000 investment by that date, should I pursue OPT working for other companies? Well, again, I mean, as John said, it's 250 is one of the markers, but not the only marker. So if you can get less, an investment of less, but you can show other indicia, other evidence of a successful business that will create jobs for US workers, it still may be worth pursuing it. But it's really going to be based on where you are in the status of your business and how strong of an application. And it's also going to depend, guys, on how long it's going to take the government to adjudicate these things. There really is simply not enough case examples for us to tell you with any specificity how long it is. But I would think that you would, at a minimum, start thinking about these requirements and thinking about putting together such an application. And when the opportunity becomes available, proceeding at that time. But absolutely simultaneously pursuing these other options. All right, what else do we got here? Okay, what happens after 30 months, Mr. Brendel? You go for the next 30 months, right?
Right.
What happens after 60 months, Mr. Brendel?
Well, that's during those 60 months, you are the beneficiary of immediate relative petition. You now your company has been a roaring success, and your EB1A, extraordinary ability in business, eligible, and so you self-petition for yourself for permanent residence that way. You are of a nationality where there is a treaty between the United States and your country of nationality, then you can be looking to the E2 visa. So those are just the three ideas that come into my head immediately for Plan B after your 60 parole months.
I think kind of the question thereafter there, let's just say you have plan A, B, C, and D, and none of them come through, and you haven't quite met the criteria at the end of the 60 months. So you could be asked to leave the country, correct?
That's right.
Okay, that's, I think what, but so what they've been saying all along is the fact is have a plan A, B, C, and D. As Larry has said repeatedly, this is not a visa status. This is not a visa. But you need to, and I would just say everybody on OPT, even if you're not going to take the parole path, is have a strategy if you want to stay in the United States. So that's why we should get an immigration attorney and discuss what the options are.
And this gives you another option. As you lay out A, B, C, and D, this is another very viable option, which previously was simply not available to our CMU and Pitt students. Okay, another question. So I can work for other companies using OPT and working on my own business at the same time. So Linda, I know I'm going to look at you on this one. I'm sure you get this question all the time. Can you work for somebody else and your own company during OPT?
Definitely on the 12-month OPT, as long as the jobs are directly related to the major field of study, it's not a problem. On the STEM extension, there you may need to do some additional work with that, but definitely the 12-month, not a problem.
Okay, perfect. I want to register my company and I will be the shareholder. Could I work for other companies and also be the shareholder of my own company during OPT? So the answer is yes. As we talk about in our Smart Start programs all the time, simply owning a company is permissible. The issue is, can you work for that company? So if you're on your OPT and you're working for another company, not only can you work for your own company, as Linda just explained, during that 12 months OPT, but you can also own it as long as you are not working for it. To work for it, you need a specific grant of employment authorization. But absolutely, as a foreign national, you can own a business.
So I'm just going to use this opportunity to make a plug for Olympus/Schwartz Center, as well as the Big Idea Center. There is a lot you can do while you're still a student. You can do the customer discovery research. You can look for potential co-founders. You can build a prototype. You can explore marketing. You can talk about what the company might look like. But do not form that company until you're ready to get your OPT, because as Larry just said, you can't work for your company. You can own it, but you can't work for it. But what we have found is when we work with those who are here on an F1 visa in particular, that we get all that stuff done. So by the time when you actually can get OPT and you're awarded it, we can turn the switch and then you're off and running because you've done all this preparation in advance. And been working with this long enough, they sort of know what you can do legally and what you can't. Although I'm not an attorney, I can't give legal advice, but there's some simple steps that you can take. But Larry and John, if you want to qualify that, or Linda, go ahead.
Let's right on, Kit. Next question, when do I apply for the parole? Can I work for myself on OPT for 1 year, then apply for the 30 months? Well, again, the timing of when you apply for this IEP is really going to be fact-based. It's going to be based on the status of your business, the status of your idea, how much money has been invested into your company, et cetera. But the scenario you raise, can I work for myself on OPT for 1 year? Linda just explained you could, and then apply for the 30 months. Yes, you could do that. The concern, of course, though, is how long is it going to take you to get your IEP? So if possible, and as John explained, you want to give yourself as much time as you can. So yes, you can work on your OPT, but you want to apply as quickly as you can on your IEP so you avoid any gap in employment authorization. Okay. Kit, I think that's the end of the questions.
Okay, I just have one more.
Okay.
Let's just say you get your IEP approved and you're only halfway through OPT. Do you have the option for when you actually turn on the IEP?
John, you want to answer that?
I haven't seen an IEP approval notice yet. But if it's like other approval notices, it's going to have an effective date. So my guess is not anything presently found in the regulations, that once you're granted this special parolee status, that's what you're on, and you're no longer an F1 student visa optional practical training person.
Okay.
And-
So I just have a comment I want to make. I did put it in chat, that these slides will be available on Pitt Center's Big Idea Center website, as well as on the Short Center website. So Linda, did you have, I thought you were about ready to say something.
Yeah, I was gonna say, there's an additional question that came to me separately, and I'll ask for the group. A question about, can students, F1 students, be shareholders of their own company while they are students?
And the answer is absolutely yes, they can. They can be an owner of the company, but the issue is, can they work for that company? And only if they have secured explicit employment authorization, whether it's CPT, which is a little shaky, or OPT, as we just discussed. Okay.
Okay, so thank you all for attending, and I particularly want to thank our panelists, Larry, John, and Linda, for happily giving this good news, and looking forward to working with you all on moving forward and getting your great ideas in play.
And I'll say, Kit, that if, as we have offered, John and I volunteer with Smart Start, as you well know. We are on campus happily. We will be back on campus with everybody in the fall. So be happy to talk to people about it then. If you have specific questions, feel free to email us. We offer consultations for CMU students at a very reduced price to help you out. So we'll be happy to talk about that. I would simply also say, just pay attention to what's happening in this area, and be thinking about these things, again, to give yourself more and more options, so that when you graduate, there are more things that you can do to be able to stay and develop your business in the United States. Okay.
Okay, so thank you everybody for attending.